Did you move in then, or what did you do?
I have issues when I go to his house. I can't go there. I have autoimmune issues.
I have also.
I wasn't talking to you.
Okay, that's nice.
You know what, young man? I'm going to tell you one thing right now, and I'm going to tell you, you better check yourself. So I'm going to give you a minute to go out into the hallway. Otherwise, what's going to end up happening is you're going to be in contempt. I was talking to Miss Cunningham. I wasn't addressing you. I don't know why you felt a necessity to interrupt her as she's addressing the court. So you might as well take yourself out of this courtroom right now. Right now. Okay, where are we?
Buckle up, guys. Today we're going to watch a courtroom situation spiral out of control in seconds. The hearing opens with instant tension as the judge asserts authority, shuts down interruptions, and makes it clear that respect for the courtroom is non-negotiable. One wrong move leads to threats of contempt and removal, setting a serious tone and signaling that this case will not be handled casually. Right away, the power balance is established, and everyone in the room knows the judge is not here to entertain excuses.
We on this? This is set for trial.
Yeah, Your Honor, to refresh the court's recollection on this particular matter, this is an action for non-payment of rent. We had a trial date set for July 26th. The landlord tried to enter on July 25th and was refused entry. We came to court, all of us ready to go forward, and the court adjourned this to today. The court ordered that the landlord enter on the 28th and the tenant provide a list of repairs. The landlord did enter, even though the power was out on the 28th, was able to fix the garbage disposal, came back on the 31st and the 1st to conduct the other repairs. A list was given on the 28th. It's landlord's position at this point, due to the refusal for entry, that any repairs that were so important are waived, and that the list that was provided on the 28th is relevant and has been completed. It's the landlord's position that has been completed, and we're seeking a judgment of possession for the full amount of rent.
Now the landlord's attorney steps in and calmly lays out the history of the case, grounding the chaos in facts. We hear about unpaid rent, failed attempts to access the unit, prior court dates, and repair orders that were allegedly completed. This segment provides the backbone of the dispute, explaining why the landlord believes they are entitled to possession and full rent. The contrast between the attorney's methodical delivery and the earlier tension makes the situation feel even more serious.
Yes, sir. So since we moved in April, I moved in. Oh.
Okay, but hold on a second. I just want to go back to when we were here on the 26th.
Sure. Yes.
You didn't permit them to enter the unit.
Right. I requested to be moved at that time, which was ignored, but they had already been in the unit in June to fix said issues, and they weren't properly fixed. So they were
Okay.
a lot of
Okay. You can obviously,
Okay.
but listen,
Yeah.
you didn't let them in,
Okay.
right?
For one of them.
So then, you let them in. You were to give them a list of things that were to be done. So let's start there. Did those get completed?
Yes.
So,
Here, the judge cuts through the narrative and targets the core issue, access. The tenant acknowledges that the landlord was denied entry at one point but later allowed in, and that repairs were eventually completed. This admission quietly shifts momentum. What started as a complaint about conditions begins to look like a self-inflicted problem. The judge's pointed questions signal skepticism, and the case starts tilting away from emotional claims toward accountability.
what are we now fighting about?
The fact that the issue was there for 3.5 months since you move in, many issues. We tried to kind fixed according to the.
Why don't you move?
At this point, I'm just will do the year, and then I would prefer just to stay at this point. But the responsiveness of Harbor One West and all that is horrifying. They don't respond to you at all. And there's been plenty of opportunities to fix the issues, and they don't.
So what is now wrong with the unit?
As of currently now, nothing, but for 3.5 months, one of the soaking wet.
Did you
And-
pay the rent?
No.
Okay, look, here's the thing. There's how much on,
Your Honor, the total balance is $5,229. The tenant hasn't paid.
This part exposes the contradiction driving the case. The tenant insists the unit had problems for months, but admits there's nothing currently wrong. The judge doesn't let that slide and redirects the discussion to rent. If the unit is now fine, the justification for not paying collapses. You can feel the tension rise as the conversation moves from complaints to consequences, and the tenant's position starts to look increasingly fragile.
since when? Excuse me, hasn't paid since when?
Since April 17th, his move-in costs were paid, and then there's not been a payment since then.
And give me that figure again, I'm sorry.
Sure. It's $5,229.68. I did put a copy of the ledger for your.
Yes. So, sir, how much do you think you owe?
When there's mold and there's a municipal.
I didn't ask what. I'm just saying, how much do you think you owe?
For until right now, nothing. There's
Seriously.
been mold.
You think you get 100% abatement?
Okay.
That's not gonna happen.
No lessee or licensee shall be obligated to pay rent for any time periods that the lessor or licensee is in violation of this section, which is section 58-122.
The financial reality hits hard when the unpaid balance is stated clearly. Over $5,000 is on the line, and the judge demands a straight answer. When the tenant is asked how much he thinks he owes, the response shocks the room. This moment changes everything, because it reveals a complete disconnect between the tenant's expectations and how the law actually works.
58-122 of what?
The premises and all common areas are
Of what?
of the municipal code of the city, I guess, to reference today.
Mhm.
Yes. To keep the premises in reasonable repair during the term of the lease or license, and to comply
Did
with.
you read the rest of that? Did you read the rest of that section?
Yes, I did.
You read the whole 58, the whole section?
No, I just read.
Did you refer to the other sections that refers to regarding a certificate of occupancy?
No,
Didn't think you did.
they weren't in compliance for over a month. I mean, I guess I don't understand.
No, I can tell.
Okay.
You gave me one section of a statute or an ordinance.
Okay.
Give me the other sections.
I don't have the other sections, Your Honor.
I didn't think so. Why don't you have the other section?
I wasn't provided them. I was speaking to legal services about this matter over and over again.
The tenant tries to justify owing nothing by citing legal code, arguing full rent abatement due to conditions. The judge listens briefly, then begins to dismantle the argument piece by piece. It becomes obvious the tenant has only partially read the statute and misunderstood its scope. What was meant to sound authoritative instead exposes a lack of preparation, and the credibility gap widens.
You want to go call them now, see if you can get the other sections? Because you're just quoting half stuff to me. You want to?
No, Your Honor.
So we can get rid of that. The COC on this building was issued when?
West was the earliest.
I know.
It was,
That had to be in February.
I believe it was in February, Your Honor. It was
And-
long before the defendant took possession of the unit.
So do you understand why what you just read doesn't apply for you?
I just don't understand why, if there's mold that's making me sick, that I've had to go to the doctor.
Do you have medical?
Yes.
Was the medical, well, okay. My goodness, look, you can't give me hearsay statements.
These are medical documents from the office visit for this mold issue, which I've emailed to.
They're hearsay.
Okay. Okay.
Your Honor, if a tenant has severe repair issues, which he claims, and mold issues, and then he refuses to let the landlord in, it just doesn't make any sense.
Here the judge's frustration becomes unmistakable. He explains why the cited law does not apply and rejects unsupported medical claims as hearsay. The contradiction is laid bare. Claiming serious repair issues while refusing entry makes no sense. This segment is pivotal because the judge openly questions the logic of the defense, signaling that sympathy alone will not overcome procedural mistakes.
And I maintain he's indicated that have been fixed. He had a city violation that was dismissed when I'm not sure what we're even arguing about. We would be more than happy to let this defendant vacate the premises.
If the previous, the escrow and the initial rent is given back to the court.
And we would not agree with the question because he moved in and hasn't paid us.
How many times are you not given access to the premises based upon the repairs? Yeah,
I believe one.
sir, that's part of the problem here. And you're going to be going out of the world backwards on this because you can't say I have repair issues. Can't say they won't respond and then deny them access.
But that was the most recent time. I did not deny them access when they came back in June to fix the issues from the complaint to the city. Said they fixed the issues and they didn't fix the issues.
The landlord reinforces their position, emphasizing they attempted to address every issue but were blocked. The judge steps in with a blunt warning, explaining that tenants cannot weaponize complaints while denying access. This moment feels like a legal lesson delivered in real time, and it becomes clear that the tenant strategy is unraveling under scrutiny.
Your Honor, not to litigate this right now, but we were notified, we thought we fixed the issues. And then the next time when we went back, when we're told that we hadn't, even though the city didn't think there was an issue, we still went back pursuant to having trial the next day and were refused. So this has not been ignored.
It was for.
What do you want?
At this point, I would feel comfortable paying rent from the point now, or at least Monday, Tuesday.
You can't do that.
Okay.
I mean,
I don't.
you denied them access. A tenant can't say there's a problem and then deny them access.
And when we had the issues the first time, we did not deny that. They came, they made their repairs, but they did not actually repair the issues. 2 days later, the city inspector came back and found them in failure to comply. I have that report.
Which, just for the record, the landlord did not receive a copy of.
I don't think that's on me. That would be on the city.
You are simply amazing.
Okay.
Ms. Cunningham, anything you want to say?
Tons, but no, thank you.
No, go ahead.
Sensing trouble, the tenant offers a last-minute compromise, saying he is willing to start paying rent now. The judge shuts that down immediately, explaining that delayed cooperation does not erase prior violations. This exchange underscores how timing matters in court, and how good intentions after the fact rarely fix earlier decisions.
So, were there points in time where either of you could not reside in the unit?
Yes.
Did you go someplace else? Just you or
Just-
both of you? Oh,
Initially, when he moved in, I was to come shortly thereafter, and when I was helping him, I actually did tell him, and we have a witness that I said it smells like mold in here, so it's wet in the second bedroom.
okay.
Uh,
Did you move in then, or what did you do?
I have issues when I go to his house. I can't go there. I have autoimmune issues.
I have also.
I wasn't talking to you.
Okay, that's nice.
You know what, young man? I'm gonna tell you one thing right now, and I'm gonna tell you, you better check yourself. So I'm gonna give you a minute to go out into the hallway. Otherwise, what's gonna end up happening is you're gonna be in contempt. I was talking to Miss Cunningham. I wasn't addressing you. I don't know why you felt a necessity to interrupt her as she's addressing the court. So you might as well take yourself out of this courtroom right now, right now.
Tension spikes again when another interruption occurs. The judge responds swiftly, threatening contempt and ordering removal from the courtroom. This second outburst reinforces the judge's control and highlights how emotional reactions only worsen a party's position. It's a stark reminder that courtroom decorum can directly affect how arguments are received.